Marshall versus ZINK.
Yes, it's full. That contemplates both states or other states.
Morning, Your Honor. Your Honors, I want to apologize for being late. We got caught in 2 detours, and by the time we finally figured our way out of it, we made
You're
it.
perfectly on time. We called your case and you were here, so
Yeah.
you're good to go.
It was quite an experience. Before we start, I'd like to tender to the court at this time. First of all, I'm Ernest Marshall. I'm a retired lawyer, and I'm appearing pro se along with my wife, who's appearing pro se. Our daughter, Jill ZINK, could not be present. We sent a letter to the court stating that both my wife and my daughter would like to adopt my oral argument in this appeal today. I inadvertently omitted a citation to the brief under point 2 concerning the records that were admitted into evidence. And I discovered this, it was too late to send a notice of supplemental authority. It's Rule 90.302 of the Evidence Code dealing with the classification of presumptions. And I have one case that is provided to the court today. The Insurance Company of State of Pennsylvania versus State of Guzman at 421 Southern 2nd, 597. It's a 4th DCA case that talks about the disappearing presumption. I provided Mr. ZINK a copy of this when I came in today. May I approach the bench?
You can hang on to it. We've got the citation, so
Okay,
we're good
thank
to
you.
go with that. Thank you.
All right. To begin, I'd like to reserve 3 minutes for rebuttal. And I'll begin by first explaining briefly the history of why we're here today. The situation started with a recent appeal by Judge Eiton of the lower court, Manatee County, on March 26, 2018, in which he partially denied a motion of the appellants, who are permanent guardians or previous permanent guardians for the children involved in this case, to release escrow funds to the appellants, which was owed to them by the appellee. Mr. ZINK is here today as permanent guardians. And it was being held for medical expense and child support arrears in 2 different trust accounts by 2 different lawyers that Mr. ZINK had in the lower court. The dissolution of marriage, this goes back, going back in time 14 years previously. A dissolution of marriage was entered by the court in Manatee County, dissolving the marriage between Mr. and Mrs. ZINK. And that dissolution of marriage was signed on January 12, 2005. Marital settlement agreement was entered into in August of 2004, in which, in that particular agreement, the former husband, Mr. ZINK, was obligated to pay $150 a week child support, and for the 3 kids, minor children, and 90% of medical expense not covered by insurance. Thereafter, 9 years later, on November 3rd, 2009, a permanent guardianship was established for the minor children, the ZINK children, in Manatee County, Florida, at which time my wife and I, were appointed as the permanent guardians of these 3 minor children who were adjudicated dependent and were removed from both the parents. Thereafter, 4 years later, after we were appointed, there was a question of repayment of past medical expense that was raised with Mr. ZINK to request him to pay it. At first, he had agreed to do it, and there was a previous order that had never been amended from the final judgment approving the marital settlement agreement that he was to pay it. And instead of paying it, he reneged on doing this. So it forced us to bring enforcement proceedings in the lower court. And it was for the medical expense only at that time, and it was totaled somewhere in the neighborhood of $8,000. We attempted to try to get the clerk during at that time to bring the action, but they said they don't enforce collection of medical expense, only child support. So at that time, I went ahead and filed the paperwork to go ahead and start the enforcement proceedings in the family law court in Manatee County. At that point, 3 months after we filed the initial enforcement proceedings on September 2013, we were forced to file an amendment to that to seek the child support that he was in arrears of. And so that became 2 items we were seeking through the enforcement proceedings, both medical expense and child support. Now, at the time that this was going on, I suffered a heart attack. That's one of the reasons I had to retire. And so Judge Williams of the lower court ordered that $15,000 for the medical expense be held in the trust account of one of Mr. ZINK's attorneys, and another $7,000 be held in the trust account of a second lawyer until further order of the court. And so at that point, we went to a hearing before Judge Eiten back in March of 26, 2018. Prior to that, actually it was in February of 2018, there were 2 2-hour hearings. And at that hearing, we presented evidence and testimony as to the sufficiency of our claim for medical expense, also the clerk's financial affidavit showing the amount of child support that was owed, and the court at that point committed 3 errors and entered an order denying the claim for child support, claiming that there was no jurisdiction reserved by any of the courts at that point, and that therefore he refused to enter an order requiring that child support be paid over to us from the clerk. The second point that he incorrectly ruled was that the total amount of child medical expense plus pre-judgment interest, he cut that from the amount that was submitted by way of affidavit and proof to the lower court, and it was not disputed with any credible evidence by Mr. ZINK, and therefore, under the evidence code presumptions that I cited to the court today, it was presumed to have been proved.
As to the medical expenses, am I recalling correctly that your position was that there was an agreement, an oral agreement, that would be reimbursed to you?
Yes, what happened back...
That's what you traveled on, was the idea of an oral agreement, correct?
No. We pointed out that there were 2 agreements. There was the initial agreement. We did cross-examination of Mr. ZINK. First, he denied there was any agreements. But on cross-examination, as we point out in the brief and in the record, he admitted to not only signing the original marital settlement agreement, which was never amended to delete the medical expense requirement, but then in 2010, he remarried to a second wife and had a child by that wife and wanted to reduce the child support to $150 so he could pay from $175 so that he could pay $20 or $25 to catch up on back child support arrearage. And we said, well, look, it's okay to get married, but why do we want to do that? And so, and then at that point he says, well, I'm also going to pay you the medical expense that I owed you, and I have money that I accumulated working for Publix and various banks and investment accounts, whatever he had. So we agreed to do that for him, and we signed a motion. He signed a motion. The court granted the motion, and also in that he had raised a point that we didn't have standing as guardians at that point. And the judge denied that issue that he had raised in his pleadings, and that was stricken. But the oral argument that you're talking about was what I just said.
Can you parse out what, on the child support arrears and on the medical, the 90% medical
Right.
side, how much each is owed to you, sir?
Pardon me?
Can you give us?
Yes, I was just going to point that out to you. The correct amount on the medical expense should be
I'm just verifying
right.
my math.
Right, okay. The child support from the clerk of the affidavit we admitted into evidence was $6,786.31 plus legal interest, and we were entitled to prejudgment interest, for a total due of $8,143.56. That's pointed out in point 2 of our brief. Also, the summary of the appellants, which we submitted into evidence that time, with the records that were in question, there was no credible evidence disputing those records by Mr. ZINK. The expenses, $15,979.86. And then when you add the prejudgment interest to the medical expense, it increased to $18,134.58. So what we're looking for from the court is $18,136.58 for the medical, and the child support was $143.56, which includes the interest. And that's how we went to the hearing before Judge Eiton. When we got into the question of those items, we brought it up, we presented it, and in his order, he said he had no authority to grant child support because the court lost jurisdiction. And we looked through everything, and as we cited in the brief, there were 3 judges, Judge Williams, Judge Gilder, and Judge Moreland. Each one of them basically reserved the jurisdiction for all further matters. But more importantly, Florida Statute 6113, paren 1, paren A, provides that there's continuing jurisdiction of the family law court at all times to enforce child support alimony, and so the statute gives a continuing jurisdiction claim. So we were permanent guardians at that point. We filed the proceedings in the Manatee County Court, which was a proper court. And then it also, juvenile rule states that 39.6221AC, that regardless if there's a permanent guardianship appointed, the father is still obligated to provide child support and medical expenses, not removed. So that's the way it came to the first point. And when you look at the orders that were entered by Judge Williams and the other 2 circuit judges, they specifically talk about reserving all further whatever had to be done in this case.
In terms of the proceeding that led to the order now before us, am I recalling correctly that the relief that your side requested was getting the funds that were the subject of the injunction, the $15,000?
I didn't understand the last part of what you said, Your Honor.
Was the relief that you were seeking in the trial court the funds that were subject to the injunction, which totaled $15,000?
Yes. Judge Moreland put that in to set it aside and was put into one of Mr. Zink's lawyers.
Am I recalling correctly that in terms of seeking additional relief under the statute, that was not pleaded as part of this proceeding that led to this order, was it?
Oh, yes, by all means. We were seeking, if you look at the motion, the sworn motion to have the trust account money paid over to us was asked for, and we pled for
The
it.
trust account money being the money that was
Yes.
subject to the injunction.
And we identified the two accounts in our sworn motion to turn over the escrow money.
Had there been a request under the guardianship statute to determine the amount of arrearages that would be collectible under the statute?
Now, you're talking about the guardianship statute per
Yes.
se versus the
Yes.
permanent guardian statute? The only thing that I can submit to you is that when we went to the hearing, we pointed out that the amount of money that was due for the medical expense was the totals that I've given to the court today. And we gave the judge the documentation to back it up. We had paid receipts. We showed on the receipts where they were paid by credit card, check, whatever. There was one bill that court was a question about that hadn't been paid to All Children's Hospital. One of Mr. Zink's children was born with a cleft palate. When we became guardians, we had to arrange by going through the University of South Florida and All Children's Hospital to get treatment for her for cleft palate, and there was about $5,000 or $6,000 that was owed. And at the time, we made the arrangements. Mr. Zink, though, agreed to pay that, but he never did. So what we're saying is that that should be paid to us, so we can pay it over to the hospital. They shouldn't get a free, there shouldn't be no free ride here of any kind because there was money available. But the answer to your question, we did not go through the guardianship court per se because we were already in the juvenile guardianship, permanent guardianship. There was no separate pleadings filed into, say, the probate court, which where the normal guardianship cases go. If that helps you to understand.
Yes, thank you.
Okay. And then, so because of what I just said, there was vested rights under this support. Once those rights occurred, there were vested rights, and we were entitled to collect them as permanent guardians. And that was the substance of our argument to point one, that there was definitely jurisdiction, and the court just didn't apply the right rules. Also, the vested rights are under the PETA case cited in that particular point. Point two, the lower court incorrectly computed the total amount of child expense and prejudgment legal interest. The lower court abused its discretion. That's where the citations I gave to the court today are important, the rebuttable presumptions. Once we did our job to bring the bills in, they weren't disputed with any credible evidence, in fact, little or none, to my knowledge, of what the transcript shows. That became proof of that fact. At that point, Judge Eiten didn't have the right to thumb through the bills and throw out the ones he wanted to leave in and leave the other ones in. It was like if it was in front of a jury trial. If in a jury trial this was a personal injury case, if the plaintiff moved for a directed verdict based on the proof they had admitted, the judge could not overrule that, and the jury couldn't interfere with it because the presumption of correctness of what was tendered as proof was sufficient to carry the day. And that's where Judge Eiten made a huge mistake in this case. So we're saying to the court that because of that, this point should also be used to reverse the order. The cases cited in there by the court were totally not on point. In fact, there's one case, the Powell case, was in favor of what we were looking to do. So the total amount that we're looking for, both the medical expense and the child support arrearages, less whatever has been ordered to be turned over to us, came to $26,280.14. Now, under point 3, this is the third point on appeal, and that is a finding that each party bears some fault in the case, and having proceeded to hearing, no fees were allowed to either one. Now,
Mr. Marshall, I just want to let you know you're at 17 minutes, and
Okay.
if you want to reserve your 3, now would be a good time to stop.
Okay, I would just simply state to the court, I think it's pretty clear that the harm, there's no such thing as harm when there's a contract to pay attorney's fees if there's a default. The marital settlement contract agreement had a contract clause in it, and it required payment of attorney's fees and cost. And when that's done, and there's been non-compliance by Mr. Zink, which there was, we're entitled to fees and costs, a matter of law. And there was no, we reserved on that, there was no hearing set for it, but yet the judge ruled on it.
Thank you. Mr. Zink?
Morning, Your Honors. Police of the
Morning.
Court. I'm Brian Zink. I'm here pro se. I just can't afford a lawyer's fees at this point. To rebut a few things, and I would like to set aside a few minutes if I could, if that's...
Actually, you're the appellee, so you don't
I
get
apologize.
further
I
argument. No,
don't
that's fine.
understand the procedures. I'll do
No,
the
that's
best I
certainly fine.
can.
Just so we're clear, the appellant has their 20 minutes. He's reserved 3. You have 20 minutes to argue your position, and then he gets to respond to whatever he'd like to respond to.
Yes, Your Honor. All right, to touch a few things here, in 2009 or so, my ex-wife Jill Zink, who had the 3 Zink children, who I'm the father, she had a drug problem. She was incarcerated. The children were removed.
Mr. Zink, let me just
We were
caution you.
divorced.
Let me just say, to the extent that this is in the record on appeal,
Yes, sir.
you can address that. I know it wasn't pointed out in the briefs, but if you're bringing up things that are not within the record, you can't. So I don't know if the drug issues are part of the record on
I'm
appeal.
sorry, but the way he referred to it was that they were removed from me, and I was a non-offending parent, and DCF gave the marshals guardianship on his good standing. They never even contacted me, and they admitted to their error when I moved for custody, and it cost me my entire retirement, which is what I used to fund the custody battle where this case has spun off from. He mentioned there was a second attorney. I don't know who he's talking about there. My only attorney was Deborah Salisbury, who withdrew after I won custody of the children, which was in 2015. Let's see. The marital settlement agreement was between myself and Jill Zink. Argues of standing for the marshals went back and forth, and being a non-lawyer, I'm not sure of the procedure, but it was always my position that that agreement was between myself and her, and as far as this oral agreement, at this point I recognize the litigious nature of Mr. Marshall, and there were no oral agreements made to fund anything, as the insurance that I had at the time covered 90% of everything as it were. As far as these bills and expenses he's claiming, the lower court found that there were duplicates, there were things out of the date range that he claimed, and I believe that was why the lower court dismissed many of the items.
Because they dated back as far as 2006?
Yes, Your
Is
Honor.
that right? Okay.
Bear with me, please. All right, it's my understanding that the marshals have been awarded $16,000. So I don't understand, he's appealing to have more money because this money in escrow is completely depleted. Based on my understanding, if that's incorrect.
Well, it appears from the trial court's order that's before us now is that there might be roughly $1,500 that was not taken out of the $15,000.
$1,500? I'm not aware of any sums remaining.
It ordered roughly $13,000. I'd have to double check it, but I thought it was about $13,500 to be paid from the money that was on hold, the
Yes, sir.
injunction money, and then the balance the court didn't deal with.
All right, well, if there's a remainder, I mean, it certainly doesn't cover what Mr. Marshall is requesting for at this point. To sum up, I've had custody of the children since 2015. They're all adults now. 2 of the 3 are living with me. I just want to keep a roof over their head and be a good father. And Mr. Marshall is, there's been volumes of litigation with this, and I would just like to see it come to an end. He's already been awarded a large amount, and I think that should be sufficient for his claims.
Do you acknowledge that there's some child support that was not paid? Because I think at one point you had acknowledged
Well,
that.
Your Honor, yes, that was covered though in this payout for When I lost employment with Publix, there was a 3 to 4 month window when I was unemployed, and that's when there was a break in the child support, okay? And yes, so there was about 3-4 months where the child support did not go out.
And as I understand the trial court's ruling, the court didn't address the child support, saying it didn't have jurisdiction to do so, but it did not reject the idea that there was still some child support that you had not paid, correct?
I'm not sure because, at that point my lawyer had withdrawn and, I'm here.
I mean, so let me phrase it a different way.
Yes, sir.
You're not taking the position that you paid every penny of child support that was owed?
My understanding is that this award that they received was the whole shebang. It was child support and medical expenses, not one or the other.
Okay. Well,
I mean,
because reading the court's order, that does not seem to be, I don't think that's a fair reading of the court's order.
All right. I would add that in the 4 years now I've been custodial parent, I've spent a fraction of what the marshal spent on medical and things of that nature, so if the court would take that into account.
Again, because that's outside of this record, we can't
Yes,
take
sir.
that into account.
I'll add that during the entire time, Mrs. Zink never paid any child support, and that was never factored into any arrearages that the court looked at either, and I've never received any child support at all, and I did request it, and some reason was given that she didn't have enough money, or perhaps she was indigent, or this or that, but I've done everything by myself to the best of my ability, and for Mr. Marshall to ask for additional money, which I don't have, I live paycheck to paycheck, and I understand this is outside of the record, but I'm trying to put a frame around this situation.
We understand.
All right, that's all, if you had any questions.
Very good. Thank you, Mr.
Thank
Zink.
you.
Briefly, as you correctly noted, much of what Mr. Zink argued was not a part of the record. Some of it was, but the vast majority of it wasn't. Concerning the business of whether or not, when we were appointed permanent guardians, that he didn't know anything about it. He was there at the time when it happened. He did not object, and the court found that it was contrary to the best interest that the children be placed with either party, regardless of who did what. So his statement to that effect was not correct. This, again, is not a part of this hearing before Judge Eiton. Now, the bills prior to 2006, anything from the date of that final judgment approving that marital settlement, whether they were owed to us or owed to anybody, he was obligated to pay because that's what he agreed to do in the marital settlement agreement. So it makes no difference whether we were seeking repayment for medical expenses when we filed the enforcement proceedings or even before, because we had an order backing us up that anything that was owed for those kids after we got to be permanent guardians had to be paid, whether it was medical expense or child support. The large award, Judge, in the eyes of maybe Mr. Zink, is large, but again, when we agreed to be permanent guardians and were asked by the state to do it, we didn't agree to use our money to pay the child support and the medical expense for those kids, especially when he had close to $80,000 in a savings account from his employment. He was asked to do this, and he agreed to do it if we lowered the child support for his fourth child that he had by second marriage. And so the bottom line to it is the claims against our daughter by Mr. Zink, those are still there. If he wants to chase claims against our daughter, he has a right to do it. That's not before the court. Today, it wasn't before the court when Judge Eiting heard the request to turn the escrow monies over to us. Those claims, if he wants to pursue them, he can chase those if he wants to, but they're not before the court today. And so for that reason, the conclusion that we have put into our brief, we request that it be granted the relief we're seeking, that the case be reversed, sent back to the lower court, be allowed to have awarded to us the child support that's in escrow plus interest, and any interest in one of these escrow accounts, we should have that. The escrow money that's in the second lawyer's account, the $6,000, $7,000, whatever it was, we want that turned over to us, and any costs connected with filing the appeal. And we thank you for your time, Your Honor.
Thank you, Mr. Marshall, Mr. Zink. That concludes the docket.